More than 30,000 views on the 11 Alive Facebook page. Police arrest a man at a Marietta IHOP, but does the punishment fit the alleged crime? Renardo Lewis faces a number of charges, including terroristic threats. The Cobb County business owner is in jail tonight on this bond, being held there. Ashley Johnson joins us now. You talk to the family, Ashley, and they really say that this is just too much for what he's accused of doing there.
His wife says police have defamed her husband and blown things out of proportion. She feared her husband would end up a statistic.
I thought they were going to kill him. I thought my husband was going to be dead. I did. I thought my husband was going to get shot.
A husband of 9 years, father of 4, now locked up for 3 days.
No! Yelling, screaming, looking at my client, automatically assuming he's up to no good.
Cell phone video shows police grabbing Lewis. According to his family, all they wanted was the corporate office's number after claiming a manager was rude to them. But police claim they were called out because he threatened employees during a dispute involving bacon.
That insinuation to reduce what happened, the assault, the attack on my client to bacon, is inflammatory.
The woman who took the video, Liz Toledo, happens to be a longtime activist who says police were 100% wrong. She was at IHOP for a family celebration and says the same manager was rude to them. Marietta police said in a statement, while the video may seem shocking to some, we are very proud that all officers used only the force necessary to place Mr. Lewis in handcuffs. Multiple officers wrestled with Lewis for roughly 90 seconds.
Mr. Lewis was not resisting arrest. He was not threatening anybody.
Legal analyst Daryl Cohen says police may have acted properly based on what was conveyed to them by IHOP employees, but in no way should Lewis be held without bond.
Based upon the evidence, whether he's guilty or not, clearly he deserves a bond and a very low bond.
All right, we're talking about a business owner.
Yeah.
This man wants to get back home to his family and to his company, but he is being held for 3 weeks. What's next?
So his attorney wants a meeting immediately with the Cobb County DA and all charges drop, and eventually they want an apology from IHOP corporate as well.
Thank you all for being here. My name is Sarah Flack and I represent Mr. Renardo Lewis. I spent a good amount of time with him this morning right over here at the Cobb County Jail, where he has been incarcerated since Saturday night, early morning into Sunday, for an incident that happened at an IHOP here in Marietta. We are here today because for the past 72 hours, the Marietta Police Department, the media have discussed this case. The case has gone viral. The video, we've all seen it at this point. And what has been said about Mr. Lewis is false. And so we are here today to tell you guys and to tell the community about who Mr. Lewis is, and to demand 2 things. Today you're going to hear from me. I'm going to speak a little bit, and then you're going to hear from 2 people. You're going to hear from Liz Toledo. She was the witness who was present at the IHOP on Saturday and who actually videoed the incident that happened. And then you're also going to hear from Ms. Franklin, who is Mr. Lewis's beloved wife of almost 10 years. They've been together almost 20 years. They both live here in Marietta, have done so for a very long time. Mr. Lewis is a business owner. He owns RC Southern Cooking in Marietta. Ms. Franklin owns a business, has been here for many, many years, and was at the IHOP on Saturday night after celebrating a family member's birthday party. They stopped in to get some food, and there was a customer service dispute, something that has happened to, I'm sure, all of us. And in that dispute, they being my client and his wife, requested corporate's phone number. So I want to clear something up right now. You guys may have heard Marietta Police has said that this case is about bacon. This case has nothing to do with bacon. And honestly, that insinuation to reduce what happened, the assault, the attack on my client to bacon, is inflammatory, it's discriminatory, and it's offensive. Most importantly, it's false. They requested corporate's phone number, and at some point the manager contacts, at least our understanding is that he contacts the police department and they show up, and you will hear from the witness, Ms. Liz, who will speak in a minute, how the second they walked in, they came in essentially guns blazing with the proverbial on a high horse, yelling, screaming, looking at my client, automatically assuming he's up to no good, because they don't know that this is a community member, a business owner, a father, a loving husband. And almost immediately, they assume, apparently they were there because somebody said that he had made threats. I haven't heard from anybody who has said he has made any threats other than the police. Nonetheless, they don't pat him down, even though they were allegedly scared. Apparently, he had made gestures to a gun. They're there for about 3 minutes, aren't seemingly scared. And at some point, you see in the video, my client, they ask her his ID, he goes to his ID, and then he kind of looks over because he hears the police getting louder with his wife, and he's concerned for her. He's her protector, he loves her, and he turns around. And at that point, you see in the video, my client gets slammed against the glass so hard that some of the witnesses thought the glass was going to break. And then you see what the Marietta Police Department has categorized as a wrestling match or a wrestle. And I want to clear something up about that too. Nothing about what happened to my client was a wrestling match, okay? It was a mob-style attack by 5 or 6 officers on top of this one man. And he's tased, he's punched, he's kicked. They knocked his tooth out. In fact, this morning, we took photographs of it. His tooth is completely knocked out. His eyes are still completely bloodshot. This was not a wrestling match. This was an attack by 5 or 6 officers on this one man. And you hear, and Liz will tell you more, he never at any point threatens anybody's life. He never resists arrest. He's in pain. And he's tased. And he's injured. And he's arrested. And nonetheless, he sits in this jail, as he has for 3 days without bond, and will apparently sit here until April 22nd without bond. And he's presumed innocent. He's got a business. He's got employees. He's got a family. But apparently, our system thinks that he is so much of a threat, so much of a danger, that he's got to sit in the Cobb County Jail for almost a month. And so that's why we're here today. We are demanding 2 things. We are demanding, one, that the GBI come in and investigate the Marietta Police Department's conduct. Marietta Police has already said they are very proud, and those are quotes. Their statement, they are proud of their officers, and so we have no faith that they're going to do any objective investigation, and so we're requesting that the GBI come in and investigate, but we're also requesting an immediate interview or immediate sit-down meeting with the Cobb County District Attorney's Office so that we can discuss these charges, discuss a bond, because nonetheless my client sits in that jail day after day after day, and he is innocent.
Are you aware that police charged him now with terroristic threats?
Yes, I am aware that they charged him with the terroristic threat, which was allegedly why they were there in the first place, but interestingly, didn't charge him with that initially. In fact, they just charged him with the terroristic threat. So I think that's an interesting fact, and I look forward to learning more about that, since that's really what allegedly has caused this whole thing.
Do you think that surveillance video from IHOP will help put some of this, help match these stories up a little better? Because like you said, these are 2 very different narratives.
I certainly hope so, and I look forward to the day where we get it.
Are you taking legal action?
Right now, our number 1 priority and concern is the criminal allegations against him. As he sits in this jail, he cannot work, he cannot provide. So I am representing him in the criminal matter, and everything else we will thoroughly investigate and make a decision at the appropriate time.
Can we get your name spelling?
Lubreez as in zebra E, FranklinLewis.
Ms. Franklin, who's here with you?
My family, his family, my friends, my close friends. Everybody's here to support us. Everybody is worried about my husband.
His 4 children are here in the
Yes.
front. If you would raise your hand, please. This is Mr. Lewis's mom, his sisters, who else?
His grandson.
His entire family.
What do you say to these IHOP employees? What do you say to this staff?
At this time, we don't have a comment, but we are requesting and requiring at some point that we get an apology for what happened. It didn't have to happen that way, shouldn't have happened that way, and it's not okay. At this time, we're not going to take any other questions. Thank you all so much for your time. We really appreciate it.
You bring my think tank tonight. They're all criminal defense attorneys. They may all disagree with me. Sarah Flack, Addison Wade, and Jesse Law, all with me tonight. Great to see you. Thank you for being here.
Good evening.
To me, what is it? I mean, is it a defense just to say that there's no eyewitness who saw this murder? How do you poke holes in topsoil and cement? That's what you got to do, because there's a videotape. And the defense admitted it in his opening statement. He says, oh, yeah, there's a videotape of her buying this stuff. Okay, that's what she was buried in. Like, walks like a duck.
What I'll say about it is
How are you going to poke a hole in cement?
well, it sounded like they were trying to be a little reserved, which is a classic thing you do in defense as a defense attorney, especially when you're not exactly sure how the testimony is going to come out at trial. Sometimes you don't want to oversell your case. So I heard a lot.
He didn't oversell anything, trust me.
He sure didn't.
No.
What I think the difference is, if I may, Vinny, the Casey Anthony case, I mean, we saw them come out with a defense theory. I mean, they came
Right.
strong. We don't have that here.
It was kind of made
more-
up, but they did have a theory.
They did, at least theoretically, and hey, it worked. But
Oh, absolutely.
here, we didn't hear exactly at all what the defense is, other than you don't.
And Taylor was found on Britt Road on the Britt family farm. It's like 17, it's like miles and miles away from where she lives. And the last person with her is the defendant.
Well, I think from a defense standpoint, though, you kind of wonder, I mean, this is somebody with law enforcement training. She's educated. You would think that if you're going to commit this murder of a friend, that you're not going to bury them on your family home. And I imagine at some point we'll hear that argument from the defense.
So do they have to say that she's being framed? Would that be a frame, or is one of the other Brits, folks? Let me bring back in my think tank on this one, and the defense seems very confident. Thoughts?
I think so, Vinny. I think that it shows they weren't confident in those two underlying, the way that they had it indicted previously. Why wait until the 11th hour? That just really does raise a question about how strong and confident they feel about their case.
So, is it easier for a female defense attorney to cross-examine these accusers?
I think so. I think that just is what it is. So I think it was a smart move on his behalf to do it. And also, I think, there's a difference between saying Me Too publicly and in public opinion or on TV versus what's in a courtroom. And so I think that that's important to make that distinction. It's one thing to sort of support that, but in court, it's a whole different standard, and it is beyond a reasonable doubt. And so that's the law. So I do think it helps to have a woman kind of make that argument.
Yeah. Do you think they're going to be attacked?
I don't think that that's going to be the strategy up front. It wouldn't be mine, and I don't think that it would be hers either. I think it's going to depend on sort of how that witness testifies and what their apparent biases or motives to lie would be. And as it comes out, if somebody's combative with you or is obviously lying, then that's maybe where you have to go and be that strong and really go there. But I don't think you start off trying to attack the victim.
Well, they could come in and say they were raped by Harvey Weinstein, right? That's what they're going to say. So if the defense can bring in that digital record of an Uber, then yeah. But I didn't hear any of that today in the opening statement.
No, I think, though, along those same lines, what's different about her is that the victim in this case is that she has a lot of these relationships with seeming volatility with the ex-husband and then the new girlfriend and maybe, sexuality and obviously dealing with her new relationship and then her friend. And that's...
Now, there's also an allegation of drugs that was made, and it seemed prosecutors acknowledged that there may have been some issues that she was experimenting or getting involved, and Cassandra's going to testify about that.
And all of that is reasonable doubt, because I imagine they'll say, well, they spent all this time looking at the defendant. Well, what all did they look into as far as the ex-husband or the girlfriend or, the Uber driver? And I imagine it'll be very little. And so there you go. That's some reasonable doubt. And I think it also will show, if they can try and poke holes in this timeline of when she was killed, that may have some beneficial impact on this case. But I just don't know yet. They were very mysterious in their opening. They were, I think, intentionally vague.
Let's talk about what I call the Allen charge light. That's what I call it, the Allen charge light, with Sarah Flack, former prosecutor, criminal defense attorney, and Will Smith, attorney who is an expert in elder law. Okay, so Sarah, you were actually sitting in the courtroom for a lot of this trial. So you had the front row seat to justice there, literally.
I did.
You did. Okay. So why is this judge not giving the full Monty Allen charge, go in, deliberate again, read from the standard instruction? Why is she doing this Allen charge light?
Well, I think given the length of the trial, it was about a week long. 6 hours isn't unusual. It would be different if we were talking 3 or 4 or 5 days and they're coming back and saying that they're deadlocked. And so right now the law doesn't require her to go forward with the Allen charge. And so that's why she did what she did.
What do you think about that?
I agree. I mean, I think
You
that's
do.
exactly why, yeah, she didn't go there, because it does. I've seen it, sort of force them into a verdict, and we don't know which way they're leaning, so it could be risky depending on what side you're on.
Well, okay, so being that you were a prosecutor and you are a criminal defense attorney, does your opinion change depending on what role you are?
No, it doesn't. I think it's just the case. And I would, looking at the charges here and the count that they are apparently still hung on, and the other ones that they apparently have reached a unanimous verdict, if I'm the defense attorney, I would not want the Allen charge at this point.
Now, looking at the charges, and the fact that you were in the courtroom for this, and I know you saw a lot of Dr. Downs, who was the forensic pathologist who testified for the defense.
Right.
Do you have any insight from what you saw in the courtroom as to where the jury is with respect to the 4 counts that they said they have reached a verdict on? Again, so all the charges, we have felony murder, underlying felony, elder neglect. Felony murder, underlying felony, elder abuse. And then we have 1 count of elder neglect, and we have 2 counts of elder abuse for different subsections. What can you tell us, Sarah, from what you saw inside the courtroom?
Well, when I sat in through Dr. Downs' testimony, I did see a sort of a split. I saw, on one hand, many jurors seem to be leaning forward and really, taking notes and thinking, sort of looking up as he would say certain things and writing notes. And then I also saw at least 2 female jurors sort of shake their head at a couple things he said, as if to maybe, it appeared that they were in disagreement with what he was saying, or just didn't think that that was believable from what I saw. So there did seem to be somewhat of a split as far as the head nods from all you can read, which is limited, but in my opinion, it seemed to be a little split.
Sarah, you probably have heard this expression, but we used to say this expression all the time in my courthouse. When the defendant testifies, it becomes all about the defendant. So even though he didn't testify, because we heard audio statement after video reenactment after audio statement, I feel like a lot of people forgot about Christine Houck.
I agree. I mean, we essentially heard him testify without being cross-examined, which is interesting in and of itself. But, I still just think there becomes this issue of, the end of the day, from the prosecution standpoint, we heard the alleged, the victim in this case, Mr. Bennett, say, he hit me.
Okay, so yeah, why didn't the prosecution give a transcript?
I don't know. That's a great question, Seema. I was wondering the same thing. I mean, that's what you do as a prosecutor, even if the audio is, but especially if the audio.
We are showing the reenactment right here so people can look at that. That is the reenactment that Landon Terrell offered up to the law enforcement and took them to the facility in Mr. Bennett's room and went through his reenactment of what he says happened that evening. So that's another statement. So yeah, let's talk about that first before we get into this transcript issue. But why would the prosecution put in 2, if not 3, self-serving statements that only help the defense and basically ensure that the defendant doesn't have to testify and be subject to cross-examination?
Well, I think in their opinion, his story doesn't make sense, and so in their mind, they wanted the jury to see this sort of outlandish, reenactment and this somewhat inconsistent statement about what happened with the victim. I think it backfired. I don't think that's actually how it came across. In fact, we see his demeanor, I think, is very sort of gentle giant, I think, as you've described it. But I think in their mind, it was supposed to show inconsistencies and implausibilities in terms of how this was supposed to have happened.
So, Sarah, why don't you tell us in your words what you think of the Allen charge is, and was this Allen charge light, as I keep calling it?
See, I think that was a perfect way to describe it, was an Allen charge light. I mean, the Allen charge in layman's terms is essentially the last official time for a final nudge, so to speak, to say, look, jury, take this seriously, give it another try, and then after that, if they don't come back with a unanimous verdict, that's at the point where the judge can declare a mistrial. But it's sort of that last push by the court to say, give this a try, keep deliberating, and let me know.
Now, Sarah, you were inside the courtroom for some of this trial. Did you notice how engaged the jurors were?
Yes. I mean, the time that I sat in, they were extremely engaged. I mean, like I've been saying, just body language and reading their body language, leaning forward, taking a lot of notes, contemplating what's being said, really listening to the expert who was testifying. They seemed very engaged, in my opinion.
Now, do you think there should have been a transcript when it's this hard to hear?
Absolutely. The jury complained about it several times, and like Sarah pointed out, I don't know why the prosecution didn't give them a transcript. They're the one that introduced this.
Is it the normal practice of a prosecutor to do this?
Absolutely. I mean, I've done it in cases where the audio was a lot more audible than this. And so certainly where you're having issues and you can't hear and there's a lot of background noise, that's why you get transcripts made.
But do you think that, Sarah, go ahead.
I was just going to add in, I think maybe the prosecutor didn't introduce a transcript here because they wanted the jury to really look at that video. And a lot of times if you have a transcript in court, the jury is looking down at what they're saying and not watching the video. So I suspect that's probably why.
There's 5 counts, 2 murder counts. 1 we know, count 1, first count of murder. The jury is reporting that they can't reach a unanimous verdict. But the other 4 counts, I guess I'm just asking you from just being someone who's like looked at at this jury and someone who's a former prosecutor, criminal defense attorney. You have all the experience in the world. What do you think is happening?
My gut on looking at these charges here is that they are deciding the issue of causation on count 1. If I had to guess, they've probably found him not guilty on counts 2, 4, and 5, and have found him guilty of count 3, elder neglect, and are now deciding if the neglect caused the death, because otherwise we wouldn't be hung on count 1. So that's my suspicion.
And so your thought is not guilty on felony murder and the counts of elder abuse.
Correct. That's my suspicion, and then they've convicted, or they've at least unanimously found him guilty on count 3. And now they're deciding if that caused the death. Because
I remember, especially when I did the long, like come back next day, next week. It was we used to always say that like we live to fight another day, and that's what it seemed like. Terrell is in good spirits.
It looked like that. It did seem like that, in my opinion.
Do you think, in your opinion, he should be in good spirits?
Well, on the defense side, all you need is 1, and so the fact that his jury is still deliberating after 7 hours. And they are, saying that they may be hung. I mean, a hung verdict is a win for the defense. It means he lives to see another day. So.
Now, Sarah, as a defense attorney, if you're representing Landon Terrell, wouldn't you have tried to bring in that information into this trial?
Not necessarily. I don't know that I would have, because I think it makes him a little more sympathetic. The less, the jury knows about his training and expertise in this area. So I don't know that I would have, and it's also not our burden. That's not our job. It's the state's job to do that. And if I were the prosecutor, I absolutely would have shown that he was trained and certified.
Do you agree about the opening the door?
I agree. I do.
Okay, but Henriksen, the defense attorney, I think it was on his closing argument. He's talking about, he's naive, he's not that sophisticated. So is that the party line that you're going with, as opposed to saying, he's a certified nursing professional extraordinaire?
Absolutely.
You think that's a better way?
That's where he went in defense. I mean, he spent a lot of time on that. And so while you can't say he doesn't have the training, find him not guilty, that's not the legal standard. It does make him a lot more sympathetic. I mean, he's here trying to do his best, maybe in over his head, as his attorney said in closing.
Sarah, Will is saying the onus is or should be on the facility. How would you use that argument in your defense?
Well, I think I would go, down the route of look at 1, how long Mr. Terrell had been there. Look at 2, who he was dealing with. This patient had many, many falls, had prior strokes, had cognitive disabilities that were either dementia or Alzheimer's. I mean, that is somebody who required a lot of specialized care. And so was Mr. Terrell the right person? Maybe there should have been someone with 19 or 14 years experience dealing with him, or 2 people dealing with him.
Oh, that's a good point.
Because of, the severity of his condition.
That is a good point. Okay. But, so I want you to compare that, Sarah, compare the prosecution's Dr. Gullidge to Dr. Downs, who you saw in the courtroom testify.
Well, I think Dr. Downs was remarkable. I mean, he came across very believable, credible, and very unbiased. I mean, they spent a long portion of his testimony talking about all of the experience he's had for the state, and that he has no interest in lying or saying something he doesn't believe to be true. And I think that he did a great job dealing with cross with the state in terms of, answering in a way that was believable. I think that his ultimate conclusion was strong, and explaining why he doesn't believe that he was assaulted, that his injuries are more consistent with a fall or a series of falls than an assault as alleged by the state.
And Sarah, what impact do you think listening to Adam Bennett's, literally his dying words, were on that jury?
I mean, obviously it's emotional and it's tragic. It's very, very sad. But I just keep going back to the fact that he doesn't tell in these moments, these 3 calls to his daughter, the one person you believe, I would imagine he can be honest and open with, and he doesn't say anything more than he's dying. He doesn't mention that somebody else did this or that somebody hurt him. So I think it's interesting, and I keep going back, why wouldn't he have said it then? But he allegedly said it, a few hours later to somebody at the nursing home. Did it happen or did it not happen?
And another thing that defense attorney Henriksen points out in his closing is that there were no screams coming out of that room. And Dr. Downs, who you saw testify, said there were no defensive wounds on Adam Bennett.